Breaking news that could fundamentally alter your immigration journey has emerged as the United States Citizenship and Immigration Services, commonly known as USCIS, has just unveiled sweeping changes in this January of 2026, dramatically reducing processing times for green cards, visas, and work permits across the board, with decisions that previously spanned years now potentially resolving in mere months. And if you are currently awaiting a decision on your case, contemplating an application, or acquainted with someone maneuvering through the complexities of the U.S. immigration system, the details unfolding in the following discussion could prove to be the most critical information you encounter this year, as these are not mere speculations or legislative proposals, but official policy implementations taking effect immediately. And in this comprehensive update, we will delineate precisely what these alterations entail for your specific circumstances. Welcome to US VisaPortal, your premier and most reliable resource for precise, current insights into U.S. immigration matters, encompassing visas, green cards, and pathways to citizenship, where our mission is to dispel the ambiguities and furnish you with straightforward, practical guidance to traverse one of the most intricate bureaucratic frameworks in the United States. Today, we are delving into the most substantial USCIS developments, heralding the start of 2026. Developments that carry genuine weight and implications. Irrespective of whether your pursuit involves a family-based green card, an employment-based visa, asylum seeker status, a work permit, or any other form of immigration benefit, these revisions will invariably influence your anticipated timelines and strategic approaches, and it is advisable to remain engaged through to the conclusion, as we will also impart expert insights on leveraging these accelerated processing durations while sidestepping prevalent pitfalls that might nonetheless impede your case. Despite the overarching enhancements, commencing with the paramount announcement that is generating widespread discourse, USCIS has proclaimed notable curtailments in processing times spanning virtually all principal case categories, stemming from a confluence of initiatives cultivated over the preceding year and now yielding tangible, quantifiable outcomes as we enter January 2026. The agency has onboarded thousands of additional personnel, deployed cutting-edge technological infrastructures, refined procedural protocols, and restructured operational flows to adjudicate cases with heightened efficiency, culminating in processing durations that, in select categories, have been diminished by 30 to 50% relative to figures observed merely 6 months prior. Turning attention to employment-based green cards, which have traditionally endured some of the most protracted delays, we are witnessing profound advancements, the Form I-140, representing the immigrant petition for alien workers and constituting the pivotal initial phase for employment-based green cards, is presently being adjudicated within an average time frame of 4 to 6 months across the majority of service centers, a marked reduction from the 8 to 12 months prevalent throughout 2025. And for those electing premium processing at an supplementary cost of $2,500, certain cases are reaching resolutions in as few as 15 business days. This expedited handling of I-140 petitions holds particular significance as it activates priority dates, enabling applicants to advance toward adjustment of status or consular processing without undue procrastination. Similarly, applications for adjustment of status via Form I-485, which facilitate the actual acquisition of a green card for individuals already present within the United States, are progressing at an accelerated pace, with current processing intervals fluctuating considerably depending on the specific field office or service center involved, yet averaging 8 to 14 months for employment-based submissions, down from the prior 12 to 24 months. Family-based adjustment applications are aligning with comparable timelines, wherein immediate relative cases, encompassing spouses, parents, and unmarried offspring under 21 years of age of U.S. citizens, frequently exhibit even swifter movement, A long-standing impediment has been the scheduling of interviews, where numerous applicants secured preliminary approvals only to languish for months or exceeding a year before receiving an interview appointment. But USCIS has achieved substantial headway in this domain by augmenting available interview slots, prolonging operational hours at high-traffic field offices, and optimizing their appointment allocation mechanisms, resulting in interview notifications typically dispatched within 3 to 6 months of a case. Attaining interview-ready status in most jurisdictions, although densely populated hubs such as New York, Los Angeles, and Miami continue to grapple with extended durations, shifting focus to work permits, formally designated as Employment Authorization Documents, or EADs. These are experiencing markedly hastened processing across every classification. For inaugural EAD applications predicated on pending adjustment of status, USCIS is finalizing the bulk of cases within 3 to 5 months, constituting a monumental enhancement over the 6 to 10-month intervals that were standard in 2024 and the initial phases of 2025. Renewals for EADs are advancing with even greater alacrity, often concluding in under 3 months. Furthermore, the automatic extension provision for designated EAD renewals has been broadened to encompass 180 days, affording applicants essential continuity and assurance amid the renewal adjudication period. This accelerated EAD processing is transformative for countless immigrants, as the capacity to engage in lawful employment is frequently indispensable for familial sustenance, career preservation, and basic financial viability while awaiting permanent residency. The distress associated with an impending expiration of a work permit, sans forthcoming approval, has inflicted considerable strain on hundreds of thousands. Thus, these ameliorations are eliciting widespread acclaim within immigrant enclaves. Likewise, travel documents, particularly advance parole authorizations that permit individuals with ongoing adjustment applications to venture abroad and re-enter the U.S., are undergoing expedited processing, with prevailing timelines hovering around 3 to 6 months. A downturn from the antecedent 6 to 12 months. USCIS has additionally amplified the issuance of combination cards that integrate both employment authorization and travel privileges into a singular document, thereby enhancing efficiency for applicants and the agency alike. Family-based immigration petitions submitted via Form I-130 are likewise benefiting from appreciable velocity gains. For immediate relatives of U.S. citizens, processing spans have contracted to an average of 9 to 13 months, diminished from 14 to 20 months. In the realm of family preference categories, those governed by visa bulletin constraints, the I-130 adjudication itself is swifter, albeit applicants must still await the currency of their priority date per the visa bulletin. Nevertheless, the accelerated I-130 handling ensures that upon priority date maturation, progression can ensue forthwith rather than being stymied by lingering petition approvals. A particular emphasis warrants placement on marriage-based green cards, which have historically encountered rigorous examination owing to apprehensions regarding fraudulent intent, engendering elongated processing periods and augmented requests for supplementary evidence. USCIS has instituted novel fraud detection methodologies that empower officers to discern potentially spurious cases with greater efficacy, concurrently expediting legitimate submissions. Authentic matrimonial cases, bolstered by robust substantiation, are now attaining approvals more promptly, with numerous couples realizing resolutions within 10 to 14 months from initial submission to green card issuance. Conversely, submissions evoking suspicions persist in attracting intensified scrutiny, and USCIS has refined its acumen in pinpointing discrepancies, underscoring the imperative of presenting exhaustive, coherent, and meticulously documented applications ab initio. These expedited timelines favor those adhering to protocols meticulously, yet afford diminished latitude for inaccuracies or deficiencies in submissions. Naturalization applications via Form N-400 en route to U.S. citizenship are similarly undergoing more streamlined adjudication, with contemporary averages spanning 7 to 11 months from filing to oath administration, reduced from 10 to 15 months. Certain field offices are demonstrating even greater celerity, consummating cases in as little as 5 to 6 months. Interview scheduling delays have abated notably, and USCIS has broadened the implementation of same-day oath ceremonies in select venues, enabling eligible applicants to pledge allegiance immediately post a favorable interview, instead of enduring protracted intervals for a distinct event. For naturalization predicated on matrimony to a U.S. citizen, the 3-year residency stipulation endures. But once eligibility is established, processing accelerates. USCIS has also elucidated aspects of physical presence and continuous residence criteria, facilitating applicants' comprehension of qualification thresholds and requisite documentation. Asylum applications alongside affiliated work permits are manifesting some progressions, although this sector remains among the more labyrinthine and encumbered. Preliminary asylum interviews are being arranged with increased promptitude in certain asylum offices, especially for affirmative asylum filings by individuals not embroiled in removal proceedings. The backlog endures as formidable, encompassing hundreds of thousands of pending matters. Yet the recruitment of supplementary asylum officers and procedural optimizations are commencing to yield discernible impacts. For EADs tethered to asylum, processing durations have ameliorated to approximately 4 to 6 months for initial requests and 2 to 4 months for renewals. The automatic extension mechanism has proven especially advantageous for asylum seekers, guaranteeing sustained legal employment authorization during renewal pendency. Now examining the catalysts propelling these enhancements. Foremost, USCIS has substantially augmented its cadre throughout 2025 and extending into early 2026. The entity has enlisted several thousand novel immigration officers, adjudicators, and ancillary personnel. These recruits have been allocated to the most overburdened service centers and field offices, directly amplifying the capability to process submissions. Secondly, investments in technology are manifesting dividends. USCIS has instituted sophisticated case management platforms, electronic submission functionalities, and artificial intelligence instruments that assist in segregating cases amenable to swift approval from those necessitating intricate scrutiny. Routine submissions devoid of complications can now be sanctioned expeditiously, liberating officers to concentrate on multifaceted cases demanding rigorous evaluation. Thirdly, USCIS has reconfigured operational paradigms and eradicated redundancies within procedures, diminishing inter-office transfers, condensing quality assurance protocols, and ameliorating intercommunication between service centers and field offices. These logistical refinements have curtailed the durations cases idle in queues awaiting assignment. Fourthly, there exists a directive impetus from administrative leadership to mitigate backlogs and elevate service standards, manifesting in explicit objectives for processing timelines, heightened accountability for postponements, and optimized resource distribution to alleviate choke points. The agency is disseminating revised processing metrics with greater frequency and exhibiting enhanced transparency concerning etiologies of delays in particular categories, transitioning to the ramifications for individuals with pending cases or those intending to initiate filings. It is paramount to recognize that these accelerated processing times constitute averages, and your particular case may diverge, either expediting or prolonging, contingent upon variables such as the assigned service center or field office. The intricacy of your submission, the comprehensiveness of furnished documentation, the issuance of requests for additional evidence by USCIS, and even stochastic variances. Should you find yourself in anticipation of a verdict with your case nearing or surpassing the normative processing interval, avenues for recourse exist, including lodging a case inquiry via the USCIS portal, engaging the USCIS contact center, or soliciting aid from a congressional liaison or the USCIS ombudsman in select scenarios. Amid these processing ameliorations, USCIS is demonstrating augmented responsiveness to probes regarding stalled cases. For prospective filers, the present juncture represents an opportune moment as processing durations oscillate in correlation with submission volumes, and with some deferring applications due to historical protracted waits. Contemporary filing influxes may be subdued relative to zenith periods, thereby fostering swifter adjudication. However, this dynamic could shift should awareness proliferate and precipitate a surge in submissions. Consequently, if preparedness for filing is attained, procrastination is inadvisable. Imperative is the assurance that your application is exhaustive and precise. Given the hastened adjudication, cases are scrutinized with alacrity, yet this concomitantly implies abbreviated windows for USCIS to solicit supplementary evidence and for responses thereto prior to rendering verdicts, proffer all mandated documents, translations, photographs, and evidentiary materials up front, employ the latest iterations of forms accessible on the USCIS website, adhere scrupulously to directives encompassing payment modalities, signature protocols, and document structuring, recurrent errors persisting in engendering delays, notwithstanding accelerated processing, encompass tendering obsolete form variants that USCIS will repudiate, remitting erroneous fees or utilizing prescribed payment instruments, omitting signatures or affixing them erroneously, proffering substandard photographs failing to conform to stipulations, neglecting to append requisite translations for non-English documents, omitting certified reproductions where obligatory, and leaving form segments vacant rather than inscribing not applicable or none upon receipt of a request for evidence from USCIS. Retort with promptitude and thoroughness, typically allotted 87 days for compliance. But in the context of expedited processing, earlier responses can propel your case forward more swiftly. Ascertain comprehension of USCIS inquiries and furnish precisely the solicited items. Incorporate a cover letter meticulously addressing each enumerated point in the request for evidence, now addressing premium processing, accessible for designated petition classifications, including Form I-129 for transient workers, I-140 for employment-based immigrants, and I-539 for status modifications or extensions in certain domains. Premium processing assures a determination within 15 business days for an additive levy of $2,500, with conventional processing accelerating. Queries arise regarding the continued utility of premium processing. The response hinges upon your exigencies. If an urgent resolution is imperative for employment commencement, visa stamping engagements, or other temporally sensitive affairs, premium processing delivers predictability unattainable via standard channels. Conversely, if temporal constraints are lax and regular timelines suffice, the premium fee can be conserved. Bear in mind that premium processing warranties a decision, not invariably an affirmation, thus potentially yielding a request for evidence or denial within the 15-day horizon for familial units traversing immigration protocols. These truncated processing intervals can signify abbreviated periods of limbo, diminished separations from kin, and expedited capacity for future planning. The psychological burden of elongated immigration trajectories is profound, hence even curtailments by several months can engender substantive ameliorations in livelihoods. For employment-based immigrants, swifter processing can facilitate prompt job initiations, career progressions unencumbered by status apprehensions, and the fortitude to undertake pivotal life choices such as property acquisitions or family expansions. Employers likewise reap advantages through expedited recruitment of essential talent with augmented timeline certitude. It merits emphasis that while processing velocities are ascending, foundational tenets of immigration jurisprudence remain unaltered. Visa allocations and preference category accumulations persist for myriad family-based and employment-based classifications. Nationals from high-demand nations like India, China, Mexico, and the Philippines continue to confront prolonged waits for visa availability, independent of USCIS processing durations. Expedited USCIS adjudication does not modify the juncture at which your priority date attains currency, yet it does ensure that upon such occurrence, subsequent phases unfold with greater dispatch. Green card possessors must still uphold U.S. residency and fulfill physical presence mandates. Accelerated processing does not amend the substantive qualification criteria for any benefit, necessitating evidentiary substantiation of authentic marriages, employer endorsements, persecution claims for asylum, or pertinent requisites for your designated case type. Addressing recurrent apprehensions and inquiries, some express trepidation that hastened processing might equate to diminished rigor in reviews and elevated error propensities. USCIS has affirmed that quality safeguards endure and that velocity gains derive from efficacy augmentations, not procedural abbreviations. Cases remain under scrutiny by proficient officers, and fraud detection apparatuses are in fact more advanced than heretofore. Others ponder the durability of these accelerations or their transience. While prognostic certainty is elusive, the infrastructural commitments, personnel expansions, and systemic refinements underpinning these truncated times represent enduring modifications poised for sustainability. Nonetheless, processing velocities could decelerate anew should filing volumes escalate markedly, budgetary constrictions materialize, or policy shifts transpire. Hence, capitalizing on the extant propitious adjudication milieu is prudent. If filing readiness is achieved, in summation, January 2026 has ushered in authentically affirmative tidings for immigrants interfacing with the U.S. apparatus. USCIS processing intervals are ameliorating substantially across nearly all primary case typologies. Green cards, work permits, travel documents, and naturalization submissions are all advancing more rapidly than in recent years. These progressions emanate from augmented staffing, superior technological integrations, procedural streamlining, and administrative prioritization. On backlog mitigation, for you, this translates to potentially months or years of abridged waiting, attenuated uncertainty, and hastened future orchestration. It signifies familial reunifications materializing sooner, laborers commencing novel vocations with expedition, and individuals realizing their aspirations in America with mitigated tension and disquiet. However, these advancements neither supplant the essentials nor obviate the necessity for diligent, accurate, comprehensive submissions. If harboring a pending case, maintain vigilance over your status and readiness for swift rejoinders to USCIS solicitations for further data. If contemplating a filing, exploit these advantageous processing climates, yet confirm eligibility and application rigor. For intricate scenarios, collaboration with accredited immigration counsel is paramount to harness these accelerations, rather than encountering setbacks from errors or oversights that encapsulates the essential knowledge regarding the principal USCIS revisions for January 2026 and their potential to advantage your immigration trajectory. We trust this elucidation has clarified the transformations and their personal relevance. At US VisaPortal, our commitment endures in apprising you of every salient evolution in U.S. immigration legislation, directives, and methodologies. These processing interval enhancements rank among the most noteworthy affirmative shifts observed in years, and we will persist in surveilling their progression in forthcoming months. Should this content have illuminated these modifications and their case implications, we encourage endorsements to amplify its reach. Enlist in US VisaPortal for continual updates on immigration developments, policy alterations, visa progressions, and utilitarian advice to navigate the framework efficaciously. Activate notifications to ensure no critical alerts elude you that might impact your case or schedule. The immigration landscape mutates, Recurrently, and informed vigilance constitutes a cardinal strategy for safeguarding your submission and optimizing success probabilities. Contribute comments detailing your encounters with USCIS processing durations, your case's current juncture, or queries pertaining to these updates. The U.S. VisaPortal community fosters mutual support, and shared narratives and inquiries aid peers in analogous predicaments. If deeming this data beneficial, disseminate it among acquaintances, relatives, or others immersed in immigration endeavors, as knowledge empowers in immigration contexts, and these revelations could profoundly influence lives. Always corroborate details from authoritative USCIS origins. Engage certified legal experts for complex matters, and eschew exploitation via assurances of assured sanctions or privileged access. The observed enhancements are legitimate and accessible to all pursuing legitimate channels. Maintain patience, remain apprised, and uphold optimism. Your immigration odyssey may pose challenges, yet with these truncated processing intervals, your objectives are nearer than previously. We appreciate your engagement with U.S. VisaPortal and anticipate reconvening in subsequent content with additional vital immigration insights.